James Alistair.
Madam Deputy Speaker, much of this bill does not apply to my constituents, because in the main this bill does not apply to Northern Ireland. But there is a key component of this bill which is supposed to apply to Northern Ireland, because the extent clause says that Part 4 applies. Of course, that is that part that deals with the very important issue of the deporting of foreign criminals. But my question to this House tonight is, will it in fact apply to Northern Ireland? Yes, this is said to be the sovereign parliament of the United Kingdom. Therefore, it is said that when this parliament decides something, that is it decided. When it applies a law to citizens in the United Kingdom, that is the end of the story. But sadly, I know, and this House needs to know, and needs to act upon it, not once, not twice, but 3 times. This House has passed bills which it said applied to the whole United Kingdom, and not once, not twice, but 3 times. The courts in this land overruled and disapplied parts of those bills to my constituents and to my part of the United Kingdom. Those were the Rwanda Bill, the Illegal Migration Bill of 2023, and the soon-to-be defunct Legacy Bill. Now, how could that be? That this sovereign parliament decides we are legislating on issues affecting constituents across this United Kingdom. We are passing laws which we say applies to them all, but which it turns out does not. Well, the answer, sadly, is Article 2 of the Windsor Framework. Because Article 2 of the Windsor Framework purports to trump this sovereign parliament. It says in respect of Northern Ireland that where there are EU laws not made by this House, laws made by a foreign jurisdiction, laws we don't make, laws we can't change, but if there are foreign EU laws which bestow on citizens or those in Northern Ireland rights which are different from the rest of the United Kingdom, then those rights will trump this sovereign parliament. That is a frightening reality, which this House, of course, has been running away from ever since it agreed to the withdrawal agreement and the protocol now called the Windsor Framework. And it comprises a fundamental assault upon not just the sovereignty of this House, but the legitimate expectations of my constituents that they will be subject to the equal citizenship that is supposed to come from being a part of this United Kingdom. And what Article 2.1 of the Windsor Framework says is that protections which are enshrined in the provisions of Union law, that's EU Union law, which are listed in Annex 1, which are a lot of provisions about rights, and of course on top of that we have the appalling prospect that never mind rights, in 300 areas of law this Parliament cannot legislate for Northern Ireland because a foreign parliament that we don't elect will legislate for Northern Ireland on many matters touching upon goods and our trade and all other sorts of matters. But when it comes to rights, there are ensconced through Article 2 of the Protocol rights which can trump the will of this House. Article 4 of the withdrawal agreement says that people can rely directly on its provisions where they meet conditions for direct effect on an EU law concept. And that, of course, is delivered by Section 7A of the European Union Withdrawal Act of 2018, which gives direct effect automatically as part of UK domestic law and says that other UK legislation must be read and applied subject to these EU provisions. And that is what has happened, and that is how the three acts I've referred to have been overruled in respect of people in Northern Ireland in the parts where they offended EU rights and legislation. Our own Supreme Court has said this: the answer to any conflict between the protocol and any other enactment, whenever passed or made, is that those other enactments are to be read and have effect subject to the rights and obligations which are to be recognised and available in domestic law by virtue of Section 7A2. In other words, if EU law says something different than our national law, then EU law applies. And it was in the Dillon case that the Court of Appeal decreed that they would disapply parts of the Northern Ireland Troubles and Legacy Act because it offended rights supposedly given to victims by EU law. Now, of course, the Dillon judgment is before the Supreme Court presently, or relevant parts of it, which will shed some light as to how far the Court of Appeal is correct about the wide application of Article 2 of the Protocol, and we await that judgment with interest. But when it came to the Illegal Migration Act of 2023, it was disapplied because it diminished asylum rights as protected by EU law. And the Dillon case makes it very clear that it's the same logic, that which is applied by Article 2 can trump this House. Now, how does that apply to the deportation of foreign criminals? Well, already, if that foreign criminal is an EU national, if they are an EU national, they already have the protection of the EU Citizens' Rights Directive, which gives them enhanced protection against deportation. So there may be two categories. There may in the Northern Ireland courts be foreign criminals who are convicted, who are EU citizens. If they are, it seems to be on doubt that they will have the added protection of the Citizens' Rights Directive of the EU. But if they're not, if they're from somewhere else and they're a foreign criminal, they are also likely to have enhanced protections which you wouldn't have in Great Britain if you were a foreign criminal convicted, because of the importation of the reliance upon the European Charter of Fundamental Freedoms. The European Charter of Fundamental Freedoms is there to assist, according to our courts, the interpretation of the European Convention on Human Rights. And in Article 19 of the European Charter for Human Rights, it affords particular protections against deportation. It says each deportation must be specifically examined. You cannot have a provision for collective deportation. And of course, the thrust of Part 4 is to create a scenario where if you are a foreign criminal convicted in our courts, then the presumption is towards deportation. And so it should be. So it does seem to me, Madam Deputy Speaker, that we are again entering into territory where a very laudable, a very necessary, a very proper provision of this House, that foreign criminals should be deported from wherever they are convicted in this United Kingdom, does seem to me that we're entering into territory where, though that is apparently the will of this House, it's a will which will be thwarted by our subjugation in Northern Ireland to the outrage of overriding EU law and provisions. That's why in the second reading of this bill, I asked the Minister about this issue. I didn't get an answer. So I'm asking the question again, because the explanatory document for this bill is totally silent on the impact of Article 2 of the Windsor Framework on its provisions. So I'm asking again for an answer. Is there a risk? Is it in fact the expectation that the provisions in respect of deportation of foreign criminals will not be able to apply in Northern Ireland? Is that conceded? Is that the expectation? Or is there an answer as to why that won't be the situation? Because, Madam Deputy Speaker, wouldn't it be outrageous if a foreign criminal in one part of this United Kingdom faces deportation as the will of this House, but if he happens to be convicted for the same offence in my part of the United Kingdom, he is cocooned from deportation? Wouldn't that be an outrage to the sovereignty of this House? Wouldn't it also create a magnet for foreign criminals to ensure if they're going to indulge themselves in crime, the best place to do it would be the place from which you cannot be deported? So it is a serious issue for me, serious issue for my constituents, but a serious constitutional issue that this House has yet to face up to. It doesn't just affect Article 2 of the Windsor Framework. It affects the very fact that there are 300 areas of law shaping much of our economy in Northern Ireland, certainly controlling our trade laws, which are beyond the reach of the sovereignty of this House and lie in the whim and the wish of a foreign parliament. That should offend each one of us as members of this House. And it should so offend us that we determined to do something about righting that wrong.